EU needs is more historians and fewer lawyers. And it seems to me that if, as a government lawyer, I think it would be an absolute delight to explore the question at very, very great length indeed. But it would take very, very great length indeed.
Thank you, all of you. Yes, gentleman at the back.
Yes, Jack Meek, Lincoln, Peter Duffy Scholar. I'll be working in the Strasbourg court from January.
So if the lady in front of you could just move her head, I would find it easier to see. Thank you. Thank you.
I suppose my question is based around the cooperation between the two institutions, the European Union and the Council of Europe, because it seems even within the European Union and locally, the point was raised that the Conservative Party is talking about withdrawing from the Human Rights Act of implementing the British Bill of Rights, but on the other side of the coin, it could be a case, however unlikely, that Britain comes out of the European Union following a referendum. And my question is based upon kind of the two-tier system that it seems to create, because if you're a member of the European Union and the Luxembourg court then gets jurisdiction and there's greater enforcement in the Luxembourg court, there could be conflict between the 19 states that aren't EU members but are Council of Europe members because they don't have the same enforcement measures. So I guess my question boils down to if the EU, or when it accedes to the convention, would there be a push for the Strasbourg court to get greater enforcement capability rather than just a declaration of compatibility for those states that aren't members of the European Union?
Thank you very much. If again I can try to summarise, if the question was on accession of the EU to the ECHR, and on the hypothesis that EU law is better executed and enforced than Strasbourg judgments are, would there be pressure for the Strasbourg court to obtain better enforcement mechanisms as a consequence of EU accession? Was that more or less what you asked?
Yes, especially keeping in mind that there would be member states of the Council of Europe that want to join the European Union, so perhaps want greater enforceability through the Strasbourg court.
Okay, thank you. The Chapter 23 stuff is what we're talking about, I think.
I just perhaps I'll extend my metaphor. I mean, that's less architecture than town planning, isn't it, really? It would be, I mean, I have little to say beyond the obvious, I guess, which is, it's more, it is genuinely, isn't it, a Strasbourg question about the comparability of mechanisms rather than the EU question. I mean, I can speculate as a lawyer about whether or not you can insert into the Strasbourg system with something which is more akin to an enforcement mechanism a la EU, but I can't say anything about the political likelihood of that happening anytime soon.
Well, because we do have this process of review of the ECHR underway. I mean, but I haven't read the documents which are coming out of it. Maybe Nuala has and has discerned whether this is an issue on the agenda. The one thing which is, of course, slightly more EU-like is Protocol 16, which only 10 states have to ratify, which provides for the final court in the states which ratify it to send questions to the ECHR and settling them at an earlier stage rather than them having to go all the way to Strasbourg. So in that way, you have a slightly more EU-like process. It's not exactly the same as the reference proceeding. There's no obligation to send it. There's no obligation to give effect to the ruling and so on. But there were certain similarities. And there was already a slight drift, generally speaking, of the Strasbourg jurisprudence to try and deal with systemic problems by giving pilot judgments and so on. It's not quite the same as the way the EU court works, of course, but it is an attempt to build in within the jurisprudence enforcement mechanisms in order to make the system work more efficiently. You could describe it like that. So that, I'm sure, will continue as much and as long as it has to continue within the existing system.
Yes, of course, Protocol 16 is only going to bind the states that ratify it, which seem to have escaped the judges in Luxembourg with the questions they were asking during the hearing. Markella.
I'm Markella Papadouli. I'm a Greek lawyer, working for the Air Center at the moment. I had a question I would like a panel's opinion. About 2 years ago, Greece launched an operation called Xenios Zeus, which pretty much involved the rounding up of migrants out of the main squares of Athens based on their physical appearances and putting them, taking their data and putting them in detention centers. Now, I was working for ECHR at the time, and what we did is we wrote a letter to the Commission asking them to commence infringement proceedings, which in fact never happened. Now, were the EU to accede to the European Convention on Human Rights, we could hold the EU Commission accountable for failure to act in this case.
Yes.
And my question pertains to, if that is the case, what would that mean for the caseload of the Strasbourg court if we were to hold and drag the EU to Strasbourg every time a member state fails to or presents systemic failures in the system, such as the Xenius Zeus operation?
Sorry, I have to repeat the question for the recording.
Right.
Will accession of the EU to the ECHR create a lever for people to require the Commission to bring infringement proceedings in cases where there is a documented breach of EU law in a particular case, like the Xenius Zeus case in Greece?
So what you're envisaging is that you would call upon the Commission to act, and if they failed to act, you would say the Commission has effectively infringed Article 3, because it would be that kind of argument.
Positive obligation to take
obligation on the
steps.
Commission. I mean, if that works in terms of the Article 3 case law, then I think that's exactly the kind of thing that accession is likely to produce, and so you would be able to do that in the Strasbourg court, and I think that's why the accession will have an effect on the EU institutions and on the European Court of Justice, because it's really what I was getting at when I was talking about convergence. Not just convergence, it's also compliance. So hopefully it will have an impact in terms of compliance. And so one of the things that the Commission is going to have to think about when deciding whether to take infringement actions is whether or not a failure to do so might breach a positive obligation on it. I think it's a very good point.
That's a fascinating suggestion. I hadn't really thought about it from that angle before. Now, I think the accession treaty is drafted so that it only applies to proceedings brought after its entry into force. Is that right? So you'd have to still be able, temporally speaking, to bring in that particular case to bring a proceeding after the accession treaty had entered into force. So to answer about that particular case. So maybe it's a continuing violation, and maybe you could still do that. But for anyone who's it is okay. Well, that's excellent. But for anything that's done and dusted right now or in the next year or two, you couldn't yet bring that proceeding. You'd have to wait for something that really is happening afterwards. Now, but that, yes, it is in principle an argument you could make against the EU, and I guess it would be along with the member state, for the substantive violation being the fault of the member state, the EU's violation being not doing what it could do to stop it. But it's also, if you go down that road, it's an example of how accession to the ECHR would alter the EU legal system in a way in which the protocol rules out. So even though there's nothing in the accession agreement or the explanatory notes, as far as I remember, to deal with that particular kind of point, I might have missed it, but it's 30 pages of explanatory notes. But even if there's nothing in there, that would be something that the Court of Justice might think, if it came to it, was an interference with the autonomy of EU law, because the Court of Justice has said for years and years and years, no, there's absolutely no obligation to bring infringement proceedings. There's total discretion on the Commission to do whatever it likes. Now, I've always said you should rethink that where there's a human rights issue. As a matter of EU law, perhaps the Charter should force a rethink. I doubt that they'd ever go down that road. But trying to argue the ECHR should force a rethink is at least worth trying. And maybe it will start the political initiative to get the Commission to change its internal rules to oblige itself to act more than it does now. So it's at least worth trying. But I think I can see that very awkward sorts of fundamental questions about the relationships between the two legal orders would be thrown up once you go down that road.
I'm not so sure that would be a difficulty, but I'm thinking off the top of my head, because the Commission's got power to act. It's just a question of exercising discretion. So no one's saying that the Commission's got to be doing something it doesn't have power to do. So I think in circumstances where you're talking about an exercise of discretion within a power which exists, then I think as a matter of theory it should be possible. But I'm just,
It's interesting.
talking on behalf of-
I too, again, I'm not going to answer the question, but as ever, the part of the mix is exhaustion of domestic remedies, isn't it? And what the internal rules might say, I guess, either directly or not. And there are directness questions too about whether or not it was that which gave rise to a continuing breach, or the relative responsibility of the member state with the EU query, or the scope of EU law issues and the purpose for which things were done, and the relationship between one policy area or purpose and function and another. So it would be one of those sort of novel and creative challenges, really. I can't imagine, though. I mean, can others?
I think you should do it. It'd be a very good case.
Absolutely.
Gosh, I'll hopefully retire by then.
Thank you very much. I think before we close, what's our time limit here? Paul, Daniel.
About an hour and a half is what we were talking about.
Can I just finally ask all of our panellists, and I didn't give you any advance warning of this, I'm sorry, what do you think are the kinds of cases that are likely to come before the ECHR if and when accession happens? What can you see being the kind of litigation that what are the cases people are going to take to Strasbourg complaining about the acts and omissions of the Union in its broadest sense?
I think you've got to ask yourself, first of all, what are the areas in which EU legislation is most often found wanting in human rights terms? If you're going to reach a sort of generalised view of what type of legislation might be challenged. And so one area possibly is transparency and sort of procedural challenges. And then you ask yourself, well, where might those arise? And I think that they might arise, for example, in competition cases, or just cases which are not obvious human rights cases, but where people have quite a lot invested in trying to get access to documents and so on. So that's just one area off the top of my head.
Steve?
There might be some fairly dull, dry cases about import licenses and things like that. But I think we might also get some asylum cases, and actually this is following on from the specific example that Marie gave. Of course, in the meantime, we have had the Tarakel judgment of the European Court of Human Rights on the 4th of November, which mentions the Supreme Court jurisprudence in the UK. It's not quite clear if they endorse it. It's not quite clear if they're extending the idea of systemic deficiencies beyond what they said or the Court of Justice said before, or they're creating a new category of family members who can't be sent back where there's inadequate or non-existent reception centres back to Italy. So, of course, there's an immediate question of how Tarakel applies. And I say it's very immediate because I just last night finished drafting a note which I sent to a Dutch lawyer who's trying to get a reference, an emergency proceeding from the Netherlands. So, we have that straight away, but I don't imagine immigration and asylum issues will be solved by the time the EU accedes to the ECHR, even if that takes 10 years. I can't imagine them being solved, and I'm sure this issues of these sort will rumble on for a while. So I could think that would be quite the most obviously significant area. But there could be some criminal suspects issues. I think a lot of practitioners were expecting the first 3, and we'll have another 3 probably EU procedural rights directives relating to criminal suspects. If they start being interpreted by the Court of Justice frequently, there will be questions about how the Court of Justice is interpreting them. Are they high enough standards as compared to the ECHR? And that could be a significant field of jurisprudence as well.
Thank you. Tim?
I sort of think geology at times like this, it's sort of big impact in numbers or people or principal cases, big impact in money cases. I mean, as a government lawyer, trying to predict the risk of litigation is, part of apparently our meat and drink. And it's very, very difficult, isn't it? But I agree with Marie and Steve. If you look at the areas of mass activity in human rights recently, the immigration has such big structural changes where there are very substantial issues at stake. Let's not kid ourselves that this is going to be particularly quick. Because if you've got a third level review after national courts have dealt with EU points and it's gone to the EU, it might have bounced back on a preliminary view and goodness knows what. This is going to be a slow and very expensive and technical process. And of course, there's a form of legal aid in the Strasbourg court, but it's not a terribly sort of generous one, particularly by English lawyers' rate standards, if I can be so cheeky. Not public sector lawyers, obviously, but
Or NGOs.
or NGOs, of course. So big structural questions, but I mean, I wouldn't dream of trying to predict those in advance. But people are going to have to be very, very committed, aren't they?
Thank you very much. Now, I thought that somebody might have drawn attention to many of the elephants in the room. Like, how is the CJEU going to have jurisdiction to hear cases which are about prior involvement without expanding its jurisdiction, without a treaty reform? What are we going to do about OLAF? What are we going to do about U4? What are we going to do about the secrecy in EU? Well, Marie referred to that, the secrecy in the CJEU proceedings. I had a whole list of them, but we've come to the end without having time. So may I ask everyone here to thank all our speakers very much indeed. To thank Daniel for having the initiative to organise this event. And to thank Freshfields yet again for their generosity in hosting it. Thank you. And last but not least, thank you to all of you for coming.